Consider a single legal document claiming the power to instantly dissolve the protective walls of sovereign immunity worldwide. On July 11, 2013, Pope Francis issued a decree that certain legal subcultures interpret as doing exactly that. The text is a Motu Proprio. In Latin, this translates to on his own impulse. It functions as an apostolic letter, an official administrative decree enacted by the Pope personally in his capacity as sovereign pontiff. Reading the literal text, the stated objective is entirely local. It was drafted to update the judicial order of the Vatican City-State. On its face, this is municipal administrative law. It establishes compliance and criminal liability rules meant specifically for the personnel and structures of the Holy See. The anomaly emerges when we look at how this Vatican text has been repurposed. A specific corpus of documents takes this local decree and stacks sweeping commentary on top of it. The attached commentary asserts that because the Holy See underpins global law, this specific Motu Proprio holds absolute global jurisdiction, overriding the United Nations and the United States. It explicitly claims to strip sovereign and official immunity from all government office holders, including the executive, legislative, and judicial branches of what it refers to as the United States Corporation. We are going to test this expansive claim strictly through the lens of established constitutional facts and the historical U.S. legal treatises that this same corpus relies upon. If this logical framework holds up, the entire structure of domestic public service liability collapses. To see if it does, we have to clinically trace its exact textual lineage. The foundation of this argument rests on the translated text of the Motu Proprio, specifically Article 3, Paragraph 4. This section defines the administrative liability of juridical persons arising from crimes that are regulated by Vatican City-State laws. The document titled Pope Removes Immunity Protection modifies this paragraph by adding an aggressive interpretation. Hint: all corporations are established under the Roman Curia. By asserting that all corporations derive their existence from the Roman Curia, the commentary claims the decree extends to the United States Corp. Under this logic, domestic officials are held personally liable for actions like asset confiscation and foreclosures. This is a massive jurisdictional superimposition. It attempts to take a mechanism of local municipal liability and stretch it into a tool of global oversight, completely bypassing any formal treaty adoption. To weigh that claim, we pivot to the constitutional baseline established in the 19th century legal treatises provided in the source corpus. Specifically, we look at a treatise on the law of public offices. The treatise outlines a core constitutional fact: no officer in the United States government holds office outside the law. Every single official has prescribed duties and explicitly limited authority. These officials derive their authority strictly from constitutional and statutory enactments. Their powers are finite, bound entirely by domestic fundamental law. Under U.S. law, no official possesses legitimate authority outside those explicitly granted domestic boundaries. If they overstep, their actions are void. The Moorish and sovereign texts attempt to weaponize this exact limitation. This document, a Moorish judicial notice and proclamation, is directed at all elected and appointed United States Republic officials. It asserts in propria persona, or proper person status, as a mechanism to separate the living individual from corporate or state jurisdiction. To enforce this separation, these documents invoke the landmark case Marbury v. Madison. The logic states that because acts repugnant to the Constitution are void, any officer acting outside their strict mandate instantly loses their legitimate authority. They are no longer acting as a protected official, but as a private trespasser. Here is where the framework plugs in the Motu Proprio. It argues that the moment an officer steps outside their constitutional bounds and loses domestic immunity, they immediately fall under the strict personal liability established by the papal decree. The theory attempts to forge a domestic loss of immunity with an international mechanism of punishment. We apply a final test to this hybrid framework using the very rules of statutory construction provided in the source materials. A cardinal rule of statutory construction is that words omitted were intentionally omitted. Courts possess no legislative power to, quote, read them into those rules and statutes. When we apply this rule directly to the Motu Proprio and to U.S. treaties, the text speaks for itself. there is no language granting the Holy See civil authority over United States officials. Extending Vatican Municipal Code to domestic U.S. officers requires reading unenumerated powers and massive global jurisdictions into the text, a direct violation of these interpretation maxims. The mechanism fails the strict textual test. One cannot legally splice international religious decrees with domestic statutes without explicit legislative text linking the two. This diagram outlines the entire constructed argument. We have Vatican administrative law on one side, U.S. constitutional treatises on the other, and the hybrid commentary attempting to fuse them together. But the connections are immediately severed by the rules of statutory construction. The constitutional bedrock remains intact. United States officers are strictly bound by the U.S. Constitution and legislative statutes alone. There is a partial truth within the provided corpus. The historical treatises do confirm that officers who act outside their legal authority perform void acts. The very rules of statutory construction the corpus relies upon prohibit the extrapolation of Vatican City administrative law into a binding global mechanism over U.S. constitutional officers.